Okay, Judge.
All right, good morning. This is Judge Alyssa Perez resuming the civil docket for the 210th District Court for February 23rd, 2022. And all matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Pantoja, would you call our next case, please?
Yes, Judge. It's cause number 2020 DCB 0749, Beacon Information Technology and Staffing Services, Inc. versus Antonio A. Murguia. Announcement of counsel, please.
Robert Skipworth, Your Honor, on behalf of Beacon Information and Technology and Staffing Services and the other third-party defendants, counter-defendants.
Good morning, Your Honor. Eric Darnell on behalf of the defendant.
Good morning. And so we are scheduled this morning for a motion hearing. Looks like we were here last week, memory serves, and the hearing on plaintiff's motion for sanctions, and then also defendant's motion to extend time to file dispositive motions were set for today. I understand we may have several other pleadings, and Mr. Darnell, I think you have emailed the court. I'm not sure if those are requests to have additional motions heard at this time. From the last hearing, we had, I think, that one outstanding matter of scheduling the summary judgment, which I had scheduled, and I see on Odyssey that it is scheduled for March 23rd, the motion for summary judgment. And so today we are hearing both the motion for sanctions and the what is actually scheduled. Was there any concern or other issues, Mr. Darnell? We're going to have to schedule, I think, whatever additional motions, because I do see there's a first amended, well, I see there's a first amended motion to extend the discovery deadline, which was filed yesterday, and an additional motion or a motion for sanctions, defendant's motion for sanctions, which was also filed yesterday. So I think as we wrapped up last week, the only outstanding motions were the two that are scheduled right now. So I would like to proceed first with defendant's motion to extend time. Mr. Darnell? Well,
Thank you,
I'm sorry, Mr. Darnell. I had
Can you hear that, or is that me?
I didn't hear anything, but I know we're speaking over one another, kind of. So before we get to that, I also saw.
Sorry, Judge, I can't hear you.
Okay, not sure what the issue is.
Just got a little bit quieter, Judge, but it's fine.
Okay, I'm not doing anything. Maybe it's just the internet acting strange. Mr. Darnell, can you hear me now?
Yes, I can, Judge. Yeah, sorry, there was interruption. Let me just start off that we have. Hello?
Yes, let me just stop you. I failed to mention, I also saw a non-suit with respect to, I believe, the third party. Well, let me see, who was it? What their names?
Yes, Judge.
The third party defendants. What I did not have was the proposed order. So if you will email that, I didn't see it attached and the clerk did not receive one. So.
Oh, okay. We can do that. Sometimes I didn't know the judges, since it's a notice as opposed to a motion. And I was looking at the title, it's not very accurate. So what I'll do is I'll amend it. And I think it moots a lot of the issues we have today as far as the circumstances. But as far as our motion, what it was is that when we had the hearing, well, I guess, so we're not having the hearing today. I guess that was my first question on the motions. You say that they're set for March. Is that correct?
So the summary judgment is set for March. The two that are set today are plaintiff's motion for sanctions and then defendant's motion to extend the deadline, which in looking at Odyssey, I see there is a first amended motion that was filed yesterday.
Yes, Your Honor. And what that is dealing with is not all the deadlines. It has to do with the previous hearing when the court had ordered us to respond within 15 days from the hearing, and because of the circumstances and the situation, that it was to extend the 15-day deadline which fell on February 14th. And I guess the response is so we were asking for more time. I think a lot of those issues are resolved by the non-suit, but we're still in the situation where we can't respond. Now, let me clarify, because there is a gross misrepresentation. We did respond. We had the issues because the order that was submitted to you was defective in that it said that we were supposed to respond, and then it referred to interrogatories. Well, don't respond to interrogatories. So what we did is we did with the best we can, realize we're the defendants, Judge, and now all we are is the defendants in the case, pursuant to you signing and approving the order of the non-suit. But it's not our burden, it's the plaintiffs, and that's what we've been trying to emphasize, and that's why we have the other motions. That's why they have to produce evidence and they have to make their case. So anyway, that being said, is that we asked for the more additional time, and we were asking for the court to wait. Oh, I guess I'm sorry, I got off. The issue is that interrogatories don't have responses. So we looked at it, and the best we could come up with in the spirit of cooperation and compliance, we did respond. We did answer interrogatories, and we did respond to requests for disclosure based on the information we have, which is problematic because the plaintiffs refused to provide any information and have never provided any evidence, which is back to why we keep wanting and urging that no evidence motions for summary judgment and default be heard. But anyway, so that being said, is all we wanted was the 15 days extended, and preferably extended beyond the time when the court rules on the motions for summary judgment, because we'll be able to answer them once the plaintiff is required to either disclose and describe their case, which is too late from our standpoint. And then I don't want to get into the details of and the name calling, but this is a frivolous lawsuit, and they've had plenty of time to document the case and create the case and make the case, but they won't give us any definition or description of the case, so we don't have any idea how to proceed other than just it's pure speculation. So that was all we had, and there was a false representation by opposing counsel saying that we didn't timely respond. Well, we did respond. If he doesn't think we timely respond, or a little different than responding and not sufficient to what he believes we can do or should do, but we did respond, and we responded to the extent we could, subject to not responding to interrogatories. We answered the interrogatories. So, and then we've taken care of some of the other issues, but additionally, there was never a response filed by plaintiff's counsel to the request to extend the time. And however the court agrees to extend it, it was timely filed, and it was filed before the deadline. It was filed on the 14th, and so it's proper, and any motion for sanctions is unwarranted, is frivolous, because we filed the motion and the request in a timely manner, and we've addressed some of the other issues. So it's our position that ask the court, and if the court will grant us additional time subject to the issues that we've mentioned, we'd still prefer to have time until after the motion's heard, because if the case is disposed of, we don't have to worry about it. So at this point in time, all we have, we're the defendants. Plaintiff still has the burden. They've always had the burden, and they have not provided or produced any evidence. So anyway, despite the court's ruling, we did timely request additional time, and ask that the 15-day deadline be extended.
So I just want to make sure I understand what you're asking, if we can just pare it down a little bit. Mr. Durnell, are you basically telling the court that you want to extend the deadline to respond until after your motion for summary judgment is heard?
Yes, because yes, it is, Judge.
But see, that was not the court's order. The court's order.
Well, I know, but that's why we responded and we timely answered within the 15 days. And all we were doing is asking the court to extend the time. But we're not imposing that that's how long the court extended. We just asked that the court extend it. But we filed answers and responses in a timely manner, and we requested in a timely manner.
So are you in your request for more time and being that there has been some response, I know Mr. Skipworth is still going to probably take issue with those responses or answers. Is there any reason to think that there is going to be a supplemental or different response with an extension of time, or are your answers and responses what they're going to be, whether there is an extension or not?
I understand what you're saying. And saying that we did respond, and we responded timely, and we responded to responses that wasn't the subject matter of the motion in the order that was granted. But that's basically it. We were asking for additional time to see if we can come up with more. It's speculative. We're having to guess, and we will do what we can. And yes, Judge, but no, it's not an all or else. I'm not saying no, that we want it after there's a hearing and a ruling, because we don't know when that's going to occur, and we were hoping that might even occur today because we'd submitted the request after the last hearing. And we don't have any notice on what the plaintiffs, on the notice of hearing that's on the docket sheet. It doesn't say, just says plaintiff's motion. It doesn't say what it is. But anyway, I'm not trying to nitpick. I'm trying to work through this and cooperate.
It is kind of nitpicking, because I'm looking at the order of court setting, and the February 23rd date, setting a hearing at 11 a.m. says plaintiff's motion for sanctions and defendant's motion to extend time. So in terms of the notice, it's there.
I was looking at the docket sheet. That was what threw me off, Judge. I'm sorry.
Well, as of the last hearing, that the new order of court setting did indicate some specificity as to what is being heard. All right, let's go. In terms of, I'm not hearing any real, well, let me ask you, Mr. Skipworth, on the defendant's motion to extend time. Do you have a response?
Moot. He responds, he sent us his garbage that he calls responses. And I'll be glad to share my screen and show you the objection that he filed. Do that. So here.
I don't know if, wow, I don't know.
I just wanted to show you the responses I got up to every interrogatory.
Sure.
Well, I'd object, Judge, because I don't know what he has, but it's not been provided to us, and I'm not sure it's the same thing.
He's the one who produced it.
Right. They're your responses, Mr. Darnell, or your, on behalf of your clients. So
we didn't produce anything, but okay, that's fine, Judge.
I am ready to rule on the motion to extend time. I agree. I don't know what to the extent, Mr. Darnell, you're still making that request, that's denied. Let's move on to plaintiff's motions for sanctions. Mr. Skipworth, you may proceed.
The motion for sanctions is based upon the responses, answers, whatever he wants to call them. Play with words as much as you want, but I feel like I'm in Alice in Wonderland in this case. He keeps repeating the same thing, saying I didn't respond. I provided evidence to the court of the number of times that I served requests or responses to requests for disclosure on Mr. Darnell. Now, in reading his new pleading he filed yesterday, he admits that he received them, but he disagrees that they're sufficient and don't give him enough information. And in prior pleadings, he said he never got them. All right, so here we are today on my motion for sanctions. The court ruled that he respond to the discovery requests, whether it's an answer, response, whatever you want to call it, by February 15th. Then on 14th, he files this motion for extension of time, but I did receive, whatever he wants to call them, responses, answers to discovery. So I'd say his motion's moot. You've already denied it. Now we go on to the motion for sanctions. The responses to the discovery. is nonsense. All it is are objections. And I mean, I'm entitled, like the one I've got. You ask him assertion, his pleading. I'm trying to find out what a pleading means. So I ask him, and I get a half a page of objections. That's it. I ask him, what is the business of AA American, AA or whatever the name of it is? Same thing. Simple. What is the business of that business? And he doesn't. So I don't think that the responses provided were sufficient. Like I say, this is just, we're going in circles. And I'd like the court simply to grant the sanctions and whatever you feel is appropriate. I've suggested things in my motion. But I know you have plenty of options at your disposal.
All right, Mr. Darnell.
Yes, Your Honor. Thank you. Plaintiff's counsel just keeps referencing the fact that they're not going to produce anything and they're not going to provide evidence, but we have to produce evidence. We don't have to make a case. We're the defendant. And the only position we're in this case still after the non-suits is the defendant. So whatever they have to have, they haven't produced. I mean, so we get into the argument of the same motion. They haven't produced any evidence of any case, so we don't know what their case is about. Everything that we could possibly respond with in actual answers to interrogatories has to do with whatever they're accusing us of, and we don't know that. I mean, this case, there's a reason why the plaintiff's counsel has been the fifth or sixth attorney in this case, because they don't have a case. And without getting specifics, Judge, they don't have a case, but they can't even tell us what the potential case is, because our answers are dependent upon what they say happened and how it occurred, so that we can respond. Just general requests about what kind of business my client is in doesn't have anything to do with the specific allegations that they're making in their lawsuit, if they had made them or if they would make them. So that's the issue. The problem that we have is we don't have anything to respond to build our case. All we can do is speculate based upon what we had, and we have non-suited those claims. We non-suited the counterclaims and the third-party claims. So those are out. That was as a courtesy to the court because of the circumstances and opposing counsel. So anyway, I don't know what else to say, Judge, other than that should have responded and he should have provided evidence, and the deadline to provide it is long past.
Okay. So I understanding frustration, everyone's frustration, to include the courts. I am, however, going to deny the request for sanctions. We have a setting on the summary judgment of March 23rd that is preceded by a final civil pretrial on March 9th. I'm not sure what we can accomplish on March 9th. But the summary judgment is set for the 23rd. So we'll see you for each of those two settings.
Well, Judge, I'm right back where I was when we first started this.
Well,
He hasn't responded to the interrogatories. I really don't have enough to respond to his no evidence motion for summary judgment without those answers. I still don't have any answers. I mean, this is the third hearing we've had.
Judge, they're the plaintiff. They're not supposed to file for. They're not supposed to file lawsuits unless they know what their case is about. They don't have any allegations. They haven't accused my client of anything. They want my client to say all these things, that I'm bad and I have a confession and like he's going to church, and that's not the case. They're supposed to have had a case when they filed it. All that does is just substantiates that that the plaintiff's counsel is that he doesn't have a case. He can't have his case until we make his case for him. What they commonly refer to as a huge fishing expedition, a deep sea fishing expedition.
Oh, Mr. Darnell, I appreciate your opinion, but everyone is entitled to good faith efforts on discovery as well. So there's clearly, I think where we're headed is really a very a restart if it's possible, but you're gonna have your motion on summary judgment, motion for summary judgment heard because it is set. And we're gonna go from there. I think it's very clear. We're gonna have to work on a few things once we get there. The only thing that is set for now is the motion for summary judgment on the 23rd. Mr. Skipworth, I do understand your frustration at this point, but we're going to take each of these matters, I guess, piecemeal, set about actually exactly a month out. So like I said, we'll see if we have any, actually don't really have a need unless you all do for that March 9th setting. I'm happy to cancel that and just see you all at the summary judgment on March 23rd.
That's fine with me, Judge. I wouldn't oppose that if
that's
that's what the court prefers.
Right. Thank you. So March
Save
9th
money.
is canceled. We'll see you on March 23rd. Mr. Skipworth, Mr. Darnell, thank you for your time.